Hi everyone, sorry, slight technical difficulty there. Welcome back to our live series. Again, I'm Rebecca, the CMO of GoStork. Hope you're all having a great day. We are so thrilled today to have Rich Vaughn on. Sorry, just seems like an Instagram issue here. But anyway, we're so thrilled to have Rich Vaughn on, who is such an expert, a leading voice in the fertility industry. And he's going to share with us all about surrogacy law and how it impacts your journey. So just bear with me for 1 second and we will add him.
I think I'm here.
Hi, sorry about that. How are you?
Oh, good.
Sometimes
How are you
Instagram
doing?
changes things.
I know. I was on and then I got kicked off, but I'm back.
Yeah, thank you so much for joining. How's it going?
Sure. Good. Good.
Good, and
Good
hi
to
to
be
everyone
here.
else joining. So many people, so glad to have all you guys. It's been great to hear how excited people are about this talk. So to start, in case you're new to us, GoStork is the only fertility marketplace where intended parents find, compare, and connect with fertility providers. And so our mission is to bring transparency to the fertility industry and to help intended parents make more informed decisions about their providers. So we're always looking to bring helpful insights and advice from the experts, as well as those who have walked the path new intended parents are about to embark on. And in you, we have both, right?
Absolutely. Yeah.
So on that note, Rich, we're so thrilled and honored today to have you. Again, your work as a leading voice in the industry is so incredible. As a brief introduction for everyone else, Rich is a father of twin boys through surrogacy and egg donation, which we look forward to hearing more about. He combined his passion for family formation with over 20 years of experience in business and technology law and founded the International Fertility Law Group, one of the world's leading firms in assisted reproductive technology law. And so today, of course, we'll be focusing on surrogacy law. And one last thing, I can't wait to get started, but for anyone who didn't get to submit a question in advance, thank you to those who did. But if you didn't, you can use your little question icon on the bottom of the screen and we will try to add it to the conversation. So, shall we?
Yeah, absolutely.
Great.
Thanks for the introduction.
Sorry?
Thank you for the introduction.
Of course. No, we're so excited to have you, and I think we'll learn so much in the next few minutes. But so to start, we'd love to hear all about you. Your own experience with egg donation and surrogacy inspired your career focus, similar to our founder and so many others passionate about helping intended parents after their own experiences. So can you just give us a little more background about your personal and professional journey, and also including your current day-to-day?
Sure. Well, first and foremost, despite all the experience that I've gained over the years, I'm first and always a parent through this process, and that's what drove me to this field. I was attracted like a bug to a light to this field when I first came upon it. When Tommy and I decided we wanted children and surrogacy was our path, we had to do what everybody else had to do, which is typically you start with a lawyer at some point and get a consultation on what it is that's involved. And so we had that initial consultation, and I found myself, really fascinated with this area of law. And I was in between careers. I had just finished a career with a startup company as in-house counsel, wearing all hats as you do in a startup company.
I hear you.
But they had sort of lost the funding for an in-house attorney, and I had a long time to look and wanted to do something that I would be really passionate about. And so I found this area of law, and I've been doing it nonstop since 2006. So that's how I got into this field. Certainly can talk about our experience going through egg donation and surrogacy. But when I joined the practice, there were two attorneys who were really just historical figures in this field that had merged their firms, and they were looking for someone to help them grow their firm into a national law firm. And so in my prior experience, I had experience with, creating a national network of distributors and sales reps in the medical technology business. And so I took that experience, combined it with my legal experience and my, personal interest in the surrogacy and egg donation area, and helped them grow a national firm. And that firm ended up becoming International Fertility Law Group. So that's a little bit about how I got started. Since then, I've helped thousands of people go through this process. Because I think we were creating a national network, it also gave me a good opportunity on a regular basis to talk to a lot of lawyers around the country in this space. And so I got to know a lot of people in this space that I might not otherwise have had the pleasure of meeting, and also had the opportunity and the reason to learn the law in all of the states, because our firm was now national.
Mm-hmm.
That sort of segued into me becoming the chair of the American Bar Association Assisted Reproduction Committee, which is a committee that sits under the family law section. So I chaired that organization's committee for 5 years, from 2013 to 2018. It was preceded by a guy named Steve Snyder, who's also somebody I think you guys know.
We do.
And he was the chair for about 7 years before me, and then after me, Dean Hutchison preceded or followed me in that position. In that work, we helped create best practice models, legislative models for not only assisted reproduction, but for assisted reproduction agencies. We get heavily involved in a lot of international policy development as well. And so I've done a lot on both the national and the international level as well.
Amazing. So you're the perfect person to walk us through this, right?
I'll do my best.
So for those brand new to researching this process, what is your role in general as part of their surrogacy journey? Like, just to start at the beginning.
Well, to those that are at the very, very beginning stages, sometimes they don't quite know where to start.
Mm-hmm.
And there's no wrong way to start, just start. So you can talk to a clinic first, you can talk to a surrogacy agency or an egg donor agency, or you can talk to a lawyer first. I think it's important, at least from my biased perspective as a lawyer, that they talk to the lawyer really early, because our job as an attorney is to help people protect themselves all the way through and keep in mind what the end goal is. For some people, the end goal is simple. They just want to make sure they're the legal parents and on the birth certificate. Mm-hmm. But for international intended parents who come here from other countries where surrogacy is not allowed, they come here, it's important that they also be able to go back home and register their child as a citizen of that country. And sometimes that requires some special work on our part, and we need to know that at the very beginning,
right?
As far as the lawyers are concerned. So start somewhere, but talk to a lawyer early on in the process so you have an understanding of the legal documents that will be involved, your rights, your risks, your obligations, how this whole thing works, and to get a professional team put together very early.
Great. Start somewhere, engage early. One of our next questions that was submitted by someone was about when to engage in surrogacy attorney. So you answered that already. So thank you for that. And so in some cases, surrogacy, sorry?
Can I add to that really quick?
Yes, please do.
So some people come to the lawyers without having really done any other research, or really at the very beginning. And, good attorneys with a good amount of experience in this field can help guide clients to agencies, to doctors, and give them other qualified referrals to other professionals in this space if they don't already have it. Some clients come to the attorneys after they've already met with the doctor or the agency, mm-hmm. in which case they may already have their team built and they just need a lawyer. So again, it's early, right. But sometimes it's really early and they don't have any other resources, right. And that's what a good attorney can help them with.
Right. And so also in some cases, surrogacy agencies connect intended parents with a surrogacy attorney. Are there sort of pros and cons of just waiting for your agency to connect you or looking on your own?
I think for a lot of people, there's a real benefit to going to an agency that can be the general contractor, mm-hmm. Or the quarterback of the whole process, and point them in the right direction, as long as it's an agency that they know and trust. And they get to, and they ask lots of questions. I mean, any parent, no matter where you start, you need to go in with your eyes wide open, ask lots of questions. And in my personal opinion, get more than one interview with, interview 2 lawyers, interview mm-hmm. 2 doctors, interview 2 agencies, and that way you can make a more informed decision. But, a lot of the agencies that have been around for a long time will be able to guide you to people that they know and trust, that they work well with, and that can work really well. For intended parents who aren't sure about that and are concerned about maybe there being a conflict of interest, that's why you seek another referral and get a second opinion and then right. make an informed decision. It's not to say that either way is a bad way. But again, do your research and make an informed decision.
Yeah, absolutely. Really good advice. And just as part of doing that research, for those who are, whether they're doing their research on their own or looking for a few different attorneys to meet with, so what do you suggest they look for in this process? And what are the top questions to ask when you're interviewing lawyers to decide who's the one?
Well, I think as far as surrogacy is concerned, it's really important to understand, well, egg donation as well, that the laws in this country vary from state to state.
Mm-hmm.
So the laws affecting surrogacy and affecting egg donation, they vary from state to state. So you either need to know exactly where your egg donor and surrogate are going to be and then talk to a lawyer in that state, or understand that you may end up looking at donors who are from 4 or 5 different states, or surrogates from 4 or 5 different states. So the first thing you want to think about with a lawyer is, where is the lawyer licensed? Because that lawyer may be limited in what he or she can do if she ends up licensed in a state that's not where the surrogate's located.
Okay.
So there can be some limitations. So that's one big thing to be talking about early on with the attorney. The other thing, of course, as with anyone else in this field, is what is their level of experience? You know, what are their, you know, who are they affiliated with? Do they own, or are they a part owner in any, you know, agency or other professional that you might be working with? And, you know, is that a conflict of interest that you need to suss out and decide if you're comfortable with? I mean, those are fair questions to ask. Just because they have an ownership interest doesn't make them a bad person, but just make sure you're aware. So it's just something to think about.
It should be really transparent, right?
Absolutely, yeah.
Yeah, okay. And so with the documentation or contracts, you know, what types of documentation will you work on together? And just sort of correlated to this, what are some of the potentially unforeseen risks or liabilities that you help predict and properly address in writing in advance to make sure intended parents are protected through these contracts?
That's a long question. Let's take the documents first.
Yes.
An assisted reproduction attorney will typically help with the basic documents, such as an egg donation agreement if you're using an egg donor, a surrogacy agreement if you're engaging with a surrogate, and will also be going to court for you to obtain a court order that declares you as the parents vis-a-vis the surrogate, so that it's clear that the surrogate's not the parent, that the intended parents are the legal parents, and that their names go on the birth certificate in the way that's most helpful to these intended parents. So those are the basics. Now, more experienced attorneys will also get involved in helping to draft estate planning documents, perhaps guardianship documents for the parents to put into writing who they would want as the guardian of the child if something were to happen to them. And this can not only help them during the surrogacy, but after the child is born as part of their estate planning portfolio. There could be advanced healthcare directives that need to be signed as well, and powers of attorney documents. Other attorneys will also, depending on their experience level with other areas of family law, they may also be able to draw up a will for the clients. You know, the thing about going through this process and forming a family is you now have a family to protect. You know, it doesn't just end with these contracts that you're putting together. So all intended parents should be thinking about the future and protecting their family with estate planning documents. So some firms in this space are able to do it, some are not, and then you just engage a separate estate planning attorney for that. Okay. So those are the basics. There are some other things that might come into play for the assisted reproduction attorney. Some attorneys will be asked to perhaps review an agency retainer agreement before the client signs it. You know, that's always something I think is a smart idea, is to have somebody look at it for you if you have any questions or concerns about the agency retainer agreement. And I think that's really it. There may be something I'm forgetting, but those
the contract with the gestational carrier.
Yeah, the contract, the surrogacy agreement. Right. I mentioned that earlier, but yeah, that's one of the basics.
The one with the agency, and then the one with the carrier, right?
Right. So there's usually, if there's an egg donor agency, there's going to be an egg donor agency retainer agreement, and then an egg donor agreement. If there's a surrogacy agency, there's an agency retainer agreement for that agency, and then a surrogacy agreement as well with the surrogate and the intended parents.
And so what are some of the most important things that should be included in the contract that you just want to make sure you're on the same page between you and the surrogate, for example?
So with the surrogacy agreement, there's quite a bit that gets addressed in these contracts. I mean, first and foremost, it's really important to understand that despite the massive production that a surrogacy entails, all the people involved, all the professionals, all the documents, insurance documents, the law, etc., it's a human process. At its very core is a deeply human, very emotional, very important, life-affirming process with real people. It's really important that with your surrogate, before you even get into the contract, that you are properly matched, because there's a relationship at the very core of all this. Now, not everybody has to have a best buddy relationship with their surrogate, but whatever relationship the intended parents want, it's important that the surrogate wants the same kind of relationship, that they have to be matched on this from the beginning, because to make this whole thing work really well, the relationship must be nurtured, and any relationship does best with good communication that both people expect and appreciate and need, and they're getting it, and also trust and respect. So I say that as well to sort of as a segue to the contract, which is the contract in a surrogacy must really fairly and respectfully balance the fact that what's involved is their baby, but her body. We have to respect both sides of that equation, and that is really essential. And so we will address, some difficult issues like abortion, and whether that's something that all parties would agree to do. If there's some danger or harm to the surrogate, of course, she always has the right to make that decision. But if there's an indication of a serious defect or abnormality with the baby, would the parents want the right to do that or not? And the surrogate has to be on the same page, but that does get addressed in the contract. That's one big area. Somewhat related to this are the risks that everybody is acknowledging as they move forward together. Intended parents have to acknowledge in the contract and personally with the surrogate that there's no way that she can guarantee what's going to happen. She's going to be reviewed and cleared by the doctors and psychologists, but there's no way for her to guarantee that she will get pregnant. There's no way for her to guarantee that she'll go full term or that the baby will be healthy or free of any defects. She can't guarantee that. She will, in the contract, guarantee that she will follow doctor's orders and do her best. But other than that, she can't guarantee the result, and the parents have to acknowledge that. And in these agreements, they basically say, look, we know you can't guarantee these things. We won't sue you if these bad results happen. On the flip side, the surrogate has to acknowledge her risks as well. And this is a major undertaking on her part. And most surrogates do this because they're good at being pregnant. They like being pregnant. But pregnancy has risks associated with it. So, and they range from nothing all the way, God forbid, to death at childbirth. And she has to acknowledge those. And we cannot be afraid to acknowledge these things. So these are the risks that she's voluntarily assuming. She's not being forced to do this. And so she knows that if these things happen to her, it's not the parents' fault. So she has to acknowledge their risks, her risks, and agree to move forward and not bring any claims against the parents. That's usually how these agreements are crafted. Now, in return, of course, the parents have to meet their obligations under the agreement, which are to, of course, pay the fees and expenses that have been outlined, but also to cover any of the medical expenses. Certainly the ones that are not covered by insurance. That's the main issue here. Anything that's not covered by insurance, by the surrogate's health insurance, will be covered by the parents. And if there are complications, typically that tail period, that period after a birth or other end of pregnancy where they have to cover these medical bills, will be extended so that she has additional time to go to more appointments and have a procedure done, get checkups and that kind of thing until the issue is resolved. So typically the parents will cover those uncovered medical bills for a longer period of time if there are complications. So that's, a quick entry into some of the medical risks and sort of the interplay, the balance between, their baby, her body. But the contract will also address her health insurance, and the risks are that insurance won't cover, that there may be a denial, and the parents have to understand that even if the insurance goes kaput, they're still responsible because she's pregnant for them. So we acknowledge that in the contract. The parties also, of course, understand that the ultimate objective in these agreements is that she is not the legal parent. She does not want to be, and she will cooperate and do and sign whatever is needed for her to do and sign to confirm and protect and establish the parents as the legal parents in this process.
Absolutely. Yeah. Everything has to be outlined fully to make sure both parties are are supported and protected. It's just so important to understand this all in advance. And just sort of on that note, another thing that we've been hearing a lot about recently is vaccinations. Can't imagine why, but I think they've found their way into contracts now, right? So, you know, if you want to require your carrier to get vaccinated for COVID or even the flu, would that go into the contract? You know, especially to make sure everyone's on the same page. You know, you want to combine anti-vaxxers with anti-vaxxers, right? Which we hope doesn't happen. And those who are open to it. So.
Yeah, that's a super important point to make, a very timely point to make right now. And we're talking about this in every surrogacy arrangement right now. There's a whole section in these agreements that will outline the sort of conduct of the surrogate during the pregnancy, and we address a variety of different lifestyle restrictions and things that she agrees to do and not do as part of any normal healthy pregnancy, like no smoking, no drinking, no drugs, you know, no dangerous activities, no skydiving, you know, in the second or third trimester, not even the first trimester. I'm just joking.
I only did that before kids, and it's never happening again.
Exactly. Same here. Same here. I did it when I was 18 and never again.
One of my first dates with my husband, which I don't think made anyone very happy.
That's an
but
incredible first date.
Not anymore. Anyway.
That's a crazy first date. But with regard to, you know, a lot of medical decisions, you know, we have to, again, realize that the surrogate ultimately gets to make those decisions. It is her body that is impacted. So parents cannot force a surrogate to vaccinate or not vaccinate. The best offense is a good defense, right? So you discuss this ahead of time. You make sure, as you mentioned, that you're matched appropriately with somebody who agrees with you on the issues of vaccination. And, you know, this was always an issue with other types of vaccinations, but it's obviously a very pressing, real-time issue now with COVID-19. So I can't stress enough how important it is that everybody discuss that prior to being matched so that there are no disagreements during the pregnancy. But ultimately, you know, it's the surrogate's health and her decision to make as to whether she gets vaccinated.
Yeah, absolutely. And actually, just for everyone to know, in the next week, we'll be publishing an article actually by Rich together with him on our blog, which will cover a lot of this. So we'll be posting here when it's live, but it'll be really informative about vaccinations and all the recommendations related to it. So look out for that. And so moving on, wanted to know more about, you know, what does the process look like as far as filing for the parental order? Can you walk us through the definitions and differences related to the pre-birth order versus post-birth order? And for, you know, each of those, like, what does the timing look like in the process?
Sure. So again, just to point back to something I said earlier, the law does vary from state to state. And so the procedures, the timing, and the documents that are needed to confirm someone as a parent in a surrogacy case will differ from state to state.
Right.
Generally, they can be broken down into two main categories. One is what I would call a pre-birth state, and the other is a post-birth state. So the majority of states allow a pre-birth order, and this is a situation where you can go to court during the pregnancy and obtain a court order signed by the judge during the pregnancy. So that's the pre-birth order. Now, one of the things to note about a pre-birth order is they are not effective until the baby is born. So it's done, it's out of the way, it's logistically more convenient this way, and immediately at birth, the parents become the legal parents. That's just a feature of this pre-birth order. In the post-birth states, obviously, by the name of it, the title, you have to wait until the birth and then go to court. So in these states, the court really just won't even open the door to you until the baby's born, until there's an actual baby, you know, alive and born to talk about. So that's the difference between the two states. Otherwise, you know, without getting into too much of the weeds here, the hoops to jump through are slightly different, but the end result is the same. In all of these cases, what we're really presenting to the court is an agreed petition. That's the goal, at least, that everybody's still in agreement, and that usually is the case if everything's done right from the beginning. But you're presenting to the court a fully agreed petition, which says to the judge, there's no dispute here. There's really almost no decision to be made. Not that the judge has to rubber stamp everything just because it's there and fully agreed. Pretty much that's how it works. If you have a fully agreed situation, all the parties to this court case are in agreement and they've reviewed and approved the court order ahead of time, then by and large, the courts are very happy to sign these court orders. This is very different than most other family law matters that family law judges will see, where people are fighting over money and nobody wants custody of a child. In these cases, there are beautiful moments where people who really have worked hard to bring about this child and to build their family, they really want to be the legal parents. They want to be responsible. So the judges are usually very happy to sign these. Unless they're new and they don't understand, what surrogacy is all about, and then we have to educate them. But in all of these cases, it's really important that the attorneys get started really early in the pregnancy to get ready for court. So in a pre-birth type of application, we would start at about 14 weeks of pregnancy. So once the surrogate is through the first trimester, which is when most miscarriages occur, and now the pregnancy is stable in the second trimester, that's the right time to start getting ready for a pre-birth court process and even a post-birth process. And at that stage, you start collecting necessary information. And it's not too early to start in a post-birth process because, look, sometimes babies come early.
Right.
We have a lot of, like I said earlier, massive production in this process, but there's still some nature involved, and babies still come early from time to time.
Mine was 2 months early, and it was a huge shock. I was just at my job, still had 2 months left to work, had a huge to-do list, and your life changes like that, But
yeah, it happens. It happens frequently, and what I often say to people about the roller coaster of the timeline is at the beginning when you're doing all your research, it's exciting because you're putting all your professional team together, and then you work on getting pregnant, and that part takes a long time, and then you're holding your breath for the first trimester, and it's like time just stands still, and then suddenly at 14 weeks it's like, okay, it's starting to get real, and then at 20 weeks, just a few weeks later, it's almost as if things are starting to happen too fast. So it's always important to be prepared early in this process. So at that stage of 14 weeks, the attorneys will gather information that would be needed to help draft the court documents. And generally speaking, in these pre-birth applications, the parties tend not to have to be present for a hearing. So it can usually be done on paper, or if if a hearing needs to happen, then the attorney can go do that. Now that does vary a little bit from state to state. There's even a pre-birth state that has a hearing process. So again, it's important to know that it does vary a lot from state to state. Okay, and then usually around 28 weeks or so, if we haven't already had an indication that the birth could happen earlier, there's complications, it's important that the attorneys are starting to talk to the hospital where the birth will be occurring, so we can start to coordinate with them. If we have a court order already, we give it to them so they can put that on file, and we let them know that if they have any questions or need any other documents at all, we can get those to them so that when the birth does occur, all of those questions have been answered, all the documentation has been provided, and that process, the birth process, can be as smooth as possible for everyone involved.
Great. A lot of details, but very helpful, right? But thank God for attorneys to walk us through this and to know all the times they need to do everything. And for LGBTQ couples, can you walk us through if there's a difference here, a need for one parent, maybe the non-biological one, to adopt? Are they both on the birth certificate, both legal parents from day one, or is that even the same thing if they're both on the birth certificate that they're both legal parents? There's a lot to that, right?
There's a lot to that, right. So in regard to surrogacy specifically, because we are going to court to get a court order that says that the intended parents are the legal parents, in most of these cases, it is not necessary for a non-genetic parent to do a further adoption. In most cases, there are some exceptions to this rule. By design, that's how it's done in Minnesota. But it's a post-birth hearing in Minnesota, and you do all three court actions at once. So you would do one court action to terminate the surrogate's rights. You do another action to establish paternity for one parent, one father, and then you do an adoption, quote unquote, for the second father to go on the birth certificate. Tennessee would do the same thing. So it does vary a little bit from state to state, although generally speaking, an adoption is not necessary for a non-genetic parent. But that's another piece of another reason why you would want to meet with a lawyer very early on, so you can find out which states are most suitable for you and what you want. Some parents wouldn't be offended by the idea that they have to go through an adoption process, and I get that. So if that's something that's important to a parent and they want to avoid that, they need to talk to a lawyer early on who can help guide them to the states that are most legally suitable for them. Now, in surrogacy, because we pretty much always go to court to get a court order, then you've got a court order that declares who the parents are. The fact that they're both on the birth certificate is a consequence of the court order.
Right.
Now, if we're taking ourselves out of surrogacy, for instance, and talking about maybe a lesbian couple where one provides the egg and the other one carries, and let's say they're married, right? Now, in many states, because they're married, they can both get on the birth certificate, but that does not mean the birth certificate is not legal parentage. It's a certificate from a state health department, basically. It means a lot, and it gets used a lot for other things as evidence that they are the legal parents, but
like
it does not
helps get a passport,
parentage.
right? But doesn't mean you're the legal parent, right?
Right. So to most protect a non-delivering mother, let's put it that way, talking about this reciprocal IVF situation where one woman carries, one woman provides the egg. It's the woman who carries and delivers who's automatically assumed to be the legal parent. That's just how our law works. We haven't needed to really clarify that until the last 30 years with surrogacy. That's the automatic assumption. So even though the other mother is the egg provider and she's the genetic parent,
right,
to best protect her with a court order that will say in any state, it will be honored under full faith and credit that she's the parent, then she must go through some formal court procedure to have her parental rights recognized. In many states, that procedure will take the form of a second parent or a step parent adoption, and the difference between the two is based on whether they're married or not. But in some states like New York, they've now have an update to their parentage statute, which says you can file a parentage petition. So you don't necessarily have to file for an adoption. So you have some options in some states.
Interesting. I think since we're also talking about reciprocal IVF now, it would be a good time to add a question that someone just asked in the chat, which is, would an IVF clinic help you with a lawyer, help connect you with a lawyer or supply recommendations, or is that something you'd have to always find on your own?
Well, some of the clinics that are much more familiar with the assisted reproduction legal arena will have suggestions. Others won't. It's easy to get resources. There's all kinds of places that you can go. There's groups like NCLR, the National Center for Lesbian Rights, Lambda Legal, Family Equality, where you can go and maybe they can direct you to an attorney if the clinic can't. But you can also search under different organizations, statewide or nationwide, for lawyers in this area.
Yeah. So. Just was connecting with Genevieve from Connecting Rainbows. I think you just met her as well. That's a good resource. It's been great to get to know her recently. She knows a lot about this topic. Yeah. So I think she has a list of lawyers as well. Are there legal implications in general related to international intended parents doing surrogacy in the U.S.? How is that different? Are there extra steps? What do they need to take? I know you kind of talked about this earlier, just briefly touched on it, but can you kind of help us in a little more detail on that? Sure.
So intended parents with nationality that's not U.S. Have other considerations. So you could be, an international intended parent in the U.S. if you are a citizen of a different country.
Right. Okay.
The issue is, do you want your child to have your citizenship in the other country? So that's the real issue that these intended parents from other countries or with other nationalities need to be thinking through. And some countries have really no position on surrogacy, but some countries have a very strong position and usually anti-surrogacy.
And that's why parents come here for it, right?
Exactly. And some countries are anti-LGBT, some are LGBT supportive. So it's all over the map. So they have lots of issues to think through, and it's important before they start the surrogacy that they think through what they want at the end for that child. And any child through a surrogacy to international intended parents, if the child is born in the U.S., the child is automatically a U.S. citizen. but to have that child recognized in the other country will take some additional work. I'll give you an example. An LGBT couple, a same-sex male couple from Italy, they cannot go back home with two men on the birth certificate.
Okay.
They just can't. I mean, we're hoping that that someday changes, but right now they can't. So they need to be prepared from the beginning, knowing that. And then if they do want a birth certificate with two men, they need to be matched in a state that will maybe perhaps allow two versions of the birth certificate. So some states will allow us through the court order, which will declare how the birth certificate should be filled out, that maybe the first birth certificate only lists one father.
Okay.
Because that would be recognized in Italy. Or maybe if they're from the Netherlands, we have to list the surrogate with the bio father on the first birth certificate, because the Dutch system doesn't recognize anyone else as the mother other than the person who delivered. So you have to give them a birth certificate with the surrogate and the bio father.
Even for a heterosexual couple?
Even for a heterosexual couple, even for a heterosexual couple where the intended mother provides her own egg. So these are some of the complications that exist from country to country. So it's important to really suss out what their nationalities are, what are their priorities as well, in terms of having that child recognized in however many countries they have nationality in. I often represent couples that have multiple nationalities between them. And we will have a discussion about which nationalities are the most important, and then sort of strategize the case based on the nationality priorities.
Have to be strategic, right?
Yeah, and again, that relates to where they can be matched, because we need to know what states are flexible with how the birth certificates can be prepared, and not all states are. Many are, but not all of them are.
Wow, yeah, it's a lot to think about, depending where you're from. Another one came in. What should intended parents be aware of and plan for as far as purchasing insurance for their baby? Particularly, again, related back to international intended parents purchasing newborn insurance. Can you walk us through that?
Sure. So for just quickly as a background, for domestic couples in the U.S., you typically have health insurance and you just add the baby to your insurance.
Right.
And when you walk in the door at the hospital, they're going to want to know where the money is. So they're going to ask for your insurance card. And then they will bill
the same as whether you're not doing surrogacy. So, yeah.
So they'll bill your insurance for the baby's medical expenses. For international intended parents, it is not often the case. It's very rare that any insurance that they may have in their home country would cover medical expenses here. There are some exceptions to this. There's private German health insurance that can be used, and there's a couple of other countries that have private insurance systems where they will reimburse the parents. So the parents will pay the medical bills to the hospital, but the insurance will reimburse. But for many intended parents in other countries, their insurance won't cover at all. So the options really are somewhat limited. There are international newborn policies, so they would want to be researching that really early in the process. I'm not an insurance expert, so I will just give that caveat. And we often will tell the clients what we know, but then refer them to an insurance broker to start looking into this. There are international newborn policies from Lloyd's of London. There's a company that used to be called Zyban. It's now called Great Morning Newborn Plan. It's based out of China. There is a plan called Allianz, which is international insurance, which a parent would get for him or herself. And have to get that about 8 months prior to the birth of this child, which means, because we don't know exactly how soon the baby could come, they have to get it in place early.
Very
and then
early.
when the baby's born, they add the baby to the policy, and it only covers a singleton. So there's differences between all of these plans, and it's important to look into them early on so they're prepared. I'll say this, knowing that there will be some people who are listening who are in the field that might not agree with it, but there are some places where perhaps, maybe, they might be able to get an Affordable Care Act policy for the child while the child is still here. But I don't know where to find them. That's something the broker can help them do. If that's a possibility, it's something they have to be very careful about with the applications, and only if it's allowed. And then there are places where there are, in some states, you go to court post-birth because that's how it's designed. And so technically, the surrogate is still the mother at the birth. And so in some very limited situations, there may be the possibility of having the child added to her policy. If there are no complications with doing so with her policy, no restrictions, we wouldn't want her to risk losing her own insurance over this. So it has to be done very carefully. And again, there's a very limited number of places where that could possibly be done. By far, the vast majority of people do not do that, and they get their own policy for the baby or deal directly with the hospital.
Right.
Hopefully, fingers crossed, it's a healthy pregnancy, and you just can pay the cash rate at the hospital.
Mm-hmm.
You never know that at the beginning how things are going to turn out.
Right.
So you can have that as a backup plan, but it is a possibility.
That's interesting about being added to the carrier's policy. That would have to be a temporary bridge, right? Is there a time limit on that?
It's a temporary bridge. It's a temporary bridge. Many agencies are not comfortable with that concept and would not allow it at all. It's by far not the preferred protocol, but Absolutely. It does happen. So it's hard to find that to begin with.
Mm-hmm. Okay, so taking things back from international back to a little more local, at least for me local, not for you right now, although mm-hmm. you have practice right in New York and California. Mm-hmm. In recent important news in the industry, as many are aware, the CPSA, the Child Parent Security Act, legalized compensated surrogacy in New York last month. We collaborated on a blog post about that, so thank you again for that. And we'll aim to dive into this in much more detail in another live, but for now, we'd love to just get your high-level perspective on what this act means for New Yorkers looking to start a family via surrogacy. And also, if you can, just kind of what are the requirements for intended parents, agencies, and gestational carriers in New York?
Sure. So the Child Parent Security Act became law in New York on February 15th, 2021, so just a little over a month ago now. Mm-hmm. What it does is it allows now parents to engage in surrogacy where the surrogate is located in New York, and the surrogate can be compensated. So for many, many years, compensated surrogacy in New York was not allowed. So if you had an altruistic surrogacy arrangement where the surrogate would not be paid compensation, mm-hmm. then that would be allowed. But now compensated surrogacy is allowed. And the bill took about 11 years to get passed. It's a monstrous piece of legislation affecting many, many pieces of mm-hmm. New York family law, domestic relations law, estate planning law, et cetera, business law.
And so many amazing advocates worked so hard on that Absolutely. For so long. So we know Absolutely. Some of them and are grateful.
Yeah, and a shout out to Denise Seidelman, who is the first person to start working on this bill 11 years ago.
Wow,
so
that's a good shout out.
She had a client that had to go through an adoption, who had been through a surrogacy but had to go through an adoption, and she rightfully felt like this is not right. We need to change that. So she mm-hmm. started this process a long, long time ago.
You second that shout out.
Yeah. So, what the law allows, I keep calling it a bill, but it's a law now. What it allows is compensated surrogacy. It sets forth some of the basic requirements, like who qualifies, who's eligible to be mm-hmm. a surrogate in New York, who's eligible to be an intended parent in New York and to be recognized as the legal parent through this process. It establishes some basic requirements for what must be in the contract itself. And it also establishes that there is this ability to get a pre-birth order, and that if the attorneys that were involved in the contract, who are, by the way, have to be licensed in New York, if they certify that the contract complies with the requirements of the law, the court is essentially required to enter a court order. I mean, unless they find some evidence as to why they shouldn't. But otherwise, it's meant to be pretty automatic that as long as the contract meets the requirements of the law, the court will enter an order recognizing the intended parents as the legal parents. The surrogate must have been a resident of New York State for at least 6 months. She must be at least 21. She must have gone through medical screening and given her informed consent to move forward. She has to be provided health insurance to cover her for the preconception care and mm-hmm. all of the maternity, and for up to 12 months after birth. That's a very long tail period with a lot of expense attached to it, so not the best thing in the world, but it's meant to protect her. Mm-hmm. So she has the ability to get any follow-up care that she needs.
Very pro-surrogate protection.
Very pro-surrogate, yeah. Another feature of the bill, by the way, is that there is a surrogate's Bill of Rights. that is part of the law. And under the law, it is required that she be given a copy of this, the parents be given a copy of the Bill of Rights at the initial consultation. So it's really, I mean, it's a very significant piece of the law, the Bill of Rights. And in addition, the surrogate must be provided with any counseling requested or needed during the process. And if she requests disability insurance coverage, she can get that as well at the parent's expense. And it also requires life insurance at, I think, $750,000 of life insurance coverage for the duration of this arrangement, as long as she qualifies for that amount. If she doesn't qualify for that amount, a lower amount could suffice. Intended parents have to be at least 21 and gone through the medical and psych evals. But they have to, at the moment, the way the bill is, or the law is written, they have to be a New York resident, and they cannot be they have to be a U.S. citizen or U.S. resident as well. So it's a way of sort of, for the people that were anti-surrogacy when the bill was being debated, it was a way to help keep the floodgates from completely crashing in on New York, out of just fear of the unknown, I think. I do believe that will change over time. There are efforts to get a cleanup bill with some changes put in place that might impact this. It's hard to say what will happen. As with anything New York, it's political, so it will take some time to get through.
Yeah, on that note, kind of my next question was, do you believe this law, not bill, right, is a first step that will continue to evolve in the future? And are there certain key ways you think that it will?
Gosh, I hope so. Yeah, I mean, any law typically evolves over time.
Good point, right? So,
so we find the weaknesses, we try to fix them through legislation, sometimes court challenges. So I do expect it will evolve. I don't have a crystal ball, though. I can't tell you exactly how long it will take for these changes to be implemented, to be passed, how much debate there will be, with the cleanup bill. We're hoping for all good things. The whole idea of the law was to make it safe to move forward with surrogacy in New York, and to protect the surrogates, to protect the parents, to protect the child-parent relationship as well, by allowing this pre-birth order application. So there's a lot of good things in it. And there's some things in it that are difficult, that will add costs, such as the health insurance for 12 months after birth. But the overall goal of the law is to do good things, and we'll refine as we go. One of the other things that you had asked about that I haven't addressed is, what requirements are there for agencies? So surrogacy agencies, which are referred to in the law as matching programs, they must be licensed if they are doing business in New York. And it's a very, very, very broad definition of what qualifies as doing business in New York. So almost anyone that practically touches anything New York will have to get licensed. So an agency, for instance, in California, with California intended parents and a California surrogate, but the clinic is in New York, that's now a surrogacy by which this agency must be licensed under the way the regulations are written. It's also something that's subject to the cleanup bill, just a quick refinement, hopefully. But right now, many agencies that are interested in engaging in surrogacy in New York are going through the process of applying to be licensed. And there's a detailed process for that. But it's the first of its kind in the US to have a requirement that agencies be licensed.
More regulation, right? A little bit.
Yeah, and this is good for the intended parents. It's a little extra work for the agencies, but it's good for the parents. It's good for the surrogate. We saw that as a need in this industry, 10 years ago. But at the ABA, the American Bar Association, we had passed a model act on licensing surrogacy agencies, and it was passed and approved by the ABA in 2016. So New York is the first state to take that up. So they followed the Model Act, they refined it and made it their own, and now it's the law.
So this has all been so informative. I have one final question, actually, in case I missed anything, or just in general, what are the frequently asked questions that you get from intended parents? Like, what's the first thing they usually ask you? Or common misconceptions, for example, that you've run into that you like to dispel right off the bat? And also, feel free to answer this from your professional side or your personal side, right? Like if people come to you saying, I'm thinking about surrogacy, and what are some of those frequently asked questions you get?
Gosh, there's quite a few, but
Mm-hmm.
the first two that come to mind, there's three that come to mind. First two are by far the most common one is, what if she changes her mind? Can she take the baby? And I reply at first in kind, and I say, when I talk to surrogates, their first question is, are you sure she's going to take the baby? Because I don't want another child. So I remind them of that, and I let them know that their question is normal. It's natural. It is the most common question that we get
Mm-hmm.
from around the world, no matter where the parents are from, the U.S. or around the world. It's the most common question.
And if they've
Um,
seen certain TV shows, they don't help at all with this misconception, which is really frustrating.
right, and then I remind them that there are horror stories out there
Mm-hmm.
of surrogacy gone wrong, and they almost always involve people skipping steps.
Mm-hmm. Okay.
Ignoring best practices, skipping steps because, the surrogate is a friend of a sister and we know her and, we don't need to do a criminal background check or we don't need to do a psych eval. Like, yes, you do.
Mm-hmm.
It's good for everybody. If you do it right and you follow best practices, these things go really well. So don't skip steps. So that's usually how the conversation evolves.
Mm-hmm.
And I could get into how the law addresses this, but generally speaking, most surrogates we have at least some case law in California where a surrogate did kind of change her mind because they got into a disagreement over something with the pregnancy. And they got to court and she said, no, I don't agree. And the court, heard all the evidence, had a full hearing and said, I see that you don't agree, but you can't. You can't change your mind now. You engage with these intended parents. You entered into this contract, using genetics that are not yours. This is not your baby. You can't change your mind. So we have some good case law in New York on that, or California on that.
Mm-hmm.
The other common questions are, how much does this cost? It's very expensive.
Mm-hmm.
And I say, look, it's not for everybody. It is expensive, but it's worth every penny. Going from my own personal perspective and having seen thousands of parents, happy parents with their baby in their arms, it's worth everything that you're going through. So all the research, all the stress, all the money, all the time, it's absolutely worth it in the end. I can't say that with more force,
And your boys are, did you say 12 now? Or
Yeah. They're 12 and a half and they're already dying to be teens. So they keep saying they're teens and
close,
preteens.
it's close.
So this is the
Oh my
little family.
gosh, the
Now,
suits.
to be fair, this is when they were 7, so they're no longer this young and cute. The taller one is as tall as me now at 12.
Oh
It's
my
like, oh
gosh.
my God. I
The
have
bow
in
ties are amazing.
Yeah,
Last
that was
last Father's Day, I got my son, who wasn't even one yet, and my husband matching bow ties and my daughter matching hair bow, and then nowhere to go with them for the next year of birthdays and weddings being canceled, but hopefully
so
we'll be out in
we
cute
were
suits soon.
we were in Texas for an in-laws wedding. I don't know if the cuteness of the bow ties was as appreciated there as it might be.
Oh,
But
I can't imagine. Oh.
anyway.
I think that's a perfect note. So, thank you again so much for your time and all of your insights today. It was so educational. It will be posted on all of our channels and our blog soon, for anyone that maybe missed some of it. If you have any more questions that you think of that you didn't get to ask us, feel free to DM us anytime, or email. We can get back to you, or we can reach out to Rich for some more expert answers. And again, like I said, look out for our article coming soon all about COVID vaccines and those implications. So we'll be sharing that. And before we go, Rich, where can people find you? Your
So you can
socials,
find me.
website, etc.
Socials and websites. The website is www.iflg.net. You can email me at rich@iflg.net. And all the other socials are on the website there, so you can find me there.
Perfect. And thank you to everyone for joining. And note if anyone has topics you'd like us to address in these lives, we'll be doing many more of them with amazing experts coming up in the coming weeks. So feel free to reach out to us with requested topics. And Rich, look forward to catching up again soon. Hope you have a great rest of your day.
Same here, Rebecca. Take care.
Thank you. Bye.
Bye,
Bye,
everybody.
everyone.